During the course of our discussion, he uttered a profanity saying I was trying to entrap him with leading questions and was not to be trusted, but it's the parent I spoke with who says he doesn't trust him. Now, there are other animals here at this facility, but officials didn't want to comment on what exactly the testing that's being done on them is. For the last 8 days, she's had no internet, no TV, and no home phone to even dial 911. Well, that would be guardian ad litem Janet Weinberger, who's been in the circuit for a number of years now. She's one of the deciding factors when a judge makes a custody decision in court. She's supposed to make a recommendation in the best interest of the child or children, but the parent I spoke with says she damaged his family instead. Mind if I ask you a few questions? This guardian ad litem, who won't face our cameras, didn't have much to say during this August encounter about the allegations this local father, Robbie Robertson, says jeopardized his daughter's well-being. It's a story we've been investigating since March, allegations that Janet Weinberger overbilled clients. And today, Robertson says he's taking the fight back to court.
So we're trying to look at doing a different type of lawsuit against Janet, maybe a class action. Just kind of wait and see. But right now, like I said, I've retained an attorney and just kind of waiting on him to move forward with it from there.
Robertson says it all started with a January 2013 order from Judge Michael Annis appointing Weinberger as guardian ad litem on his custody case.
She's on a case 10 months. I received one bill from her, and that bill was a lot of errors.
One bill. The order appointing Weinberger to this case compelled her to send a bill for every single month she was on the case. But this father says the bill dated October 28th, 2013 didn't add up.
Every time Janet Weinberger called me, which was 41 times, I was charged a $13 fee, which half went to my wife at the time and then the other half went to me.
According to Judge Annis's order, Weinberger could charge $65 an hour. That means she was billing 12 minutes for each no-answer phone call. But Robertson says that's not the most outrageous charge on the $845 bill.
Janet Weinberger indicated that she spoke with all my teachers involving my daughter and my stepdaughter.
According to Robertson, the teachers say otherwise.
I have emailed all the teachers and they have emailed me back, and in those responses they indicated that they did not speak or talk with Janet Weinberger at all.
Robertson provided WFXG copies of those emails and their responses, in which the teachers appear to say they never spoke to or met with Weinberger. Now back to those $13 phone calls. The charges for what Robertson says were calls that were never made totaled $162.50. Just on the October bill. But then this father says another bill surfaced when he tried to contest the charges.
She got very upset, and 20 days later I received a new bill for $1,453.08.
The new bill, dated November 21st, 2013, suddenly included countless more charges that allegedly were incurred before the October bill was sent. Robertson says he'd had enough, but when he brought the issues up to Judge Annis, he says his concerns fell on deaf ears, even though the judge's order states if either party feels the guardian's bill is unreasonable, they can address the issue by motion and hearing or by conference.
Judge Annis's comment was that Janet Weinberger made an effort to call me, and because she made an effort to call me, that I was responsible for paying it.
So we contacted Judge Annis ourselves. In an email, he said it was his policy not to comment on cases that are active or pending appeal. WFXG also received other complaints about billing issues involving Weinberger's work, but those litigants didn't want to go on camera to discuss their issues. Our next stop for answers was Janet Weinberger herself, but she didn't return our phone calls. So we tried to bring our questions to Weinberger in person following an after-hours meeting of select guardian ad litems in Judge David Roper's chambers. I'm trying to get in touch with you. Mind if I ask you a few questions? Why? Are you hiding anything? Weinberger quickly ducked into her vehicle, evading my questions. Janet, I just want to talk to you for a second. Can we talk? Janet, what are you hiding? Now, since my encounter with Weinberger in the courthouse parking lot, we tried to reach her again for comments on the Robertson case. She texted me saying the judges prohibit her from discussing cases on which she is a guardian ad litem. We also tried to reach her again for comment after reports that Robertson now plans to sue her, but we've yet to hear back. Well, Saria, they say they're afraid the pattern will continue and they don't want other parents to go through what they have. They've agreed to speak on condition we hide their identities.
We've always done things together and inseparable.
That's how this mother, a military veteran currently serving in the United States Army, describes her relationship with her children before a court order took them away from her. Court documents show her case in 2011 was assigned a guardian ad litem, a person appointed by the judge in a custody dispute to make recommendations. That person was Doug Nelson, who presently serves as a Columbia County magistrate judge. The mom says Nelson met her at an Augusta motel for a meeting when she says the situation took a bad turn.
We're walking outside the parking lot and he puts his hand around me and he's rubbing my arm up and down, but then he puts his hand on my back, starts rubbing my back all the way down to my bottom, that's in my rear. And I'm like, this is no way for a guardian ad litem to be carrying himself with nobody.
She made a report this year to the Richmond County Sheriff's Office. Investigators say they're still looking into the allegations. She says he eventually ended contact with her and wrote his report, which she believes ultimately led to her custody being revoked.
This judge basically has made it a point to make my life miserable, saying that no, I was not going to get the children back because I manipulated their minds, but no one has even talked to the children.
According to Nelson's final report in her case to Judge Daniel Craig, he didn't list the kids as interviewees when making his report, but said this mother alienated the kids from their father. According to the document, he did, however, interview 6 people with listed relationships to the father, but none for the mom. Nelson also gave a 2-paragraph status update for the father, describing what he believed to be the father's touching hobby of writing books on social issues. The mom got 2 cut-and-dry sentences stating her name, location of residence, and Army pay grade. The report states Nelson ultimately recommended custody for the father because of the mother's willful and intentional alienation of the children. After hearing the allegations, we tried to reach out to Nelson. A court secretary gave us a cell phone number to reach him on. Nelson said 7 words, didn't happen, all I have to say. One of the witnesses Nelson interviewed in this case, who doesn't have a custody case, is now making allegations of her own. She says he arranged a follow-up meeting where she says he asked about her personal life.
His specific comment was, well, now that he's gone, you definitely are going to be meeting a man in your life, and I know how to take care of that.
In another case, another mom says Nelson sent her inappropriate text messages while working on her custody case just 2 years ago, and also asked her what she calls inappropriate questions in person.
He came right out and said, you know, what was your sex life like? And I was thinking, okay, I have a problem.
She included screenshots of the messages in a brief we obtained that was filed with the court clerk's office to Judge Daniel Craig. When we reached out to Craig, he said it would be improper for a judge to discuss the accuracy of a brief like the one filed, and that this case is pending trial. Sent from a phone number we confirmed through magistrate court offices as belonging to Nelson, the messages we read say he wanted to touch and also discussed the mom's attire when she told him what she would be wearing to a hearing. Nelson responded, "Giddy up, can't wait to see." And there's another case. In a statement to the Columbia County Sheriff's Office this year, another woman alleges in 2012 that Nelson pulled her body right up to his and stroked her arm and back.
And I couldn't believe it. I'm not easily offended. I've worked around a lot of men single-handedly, and being in the military, sexual harassment and all that. And I knew clearly what it was.
That case also still under investigation, police say. After hearing the additional allegations, we reached out to Nelson again. He sent me a statement via text message reiterating these are allegations only, and he works cases where he says people lash out because of kids being involved. Nelson says these women are looking for a reason to get back in court, but when asked pointed questions about the proof the women say they have, including those screenshots of text messages, he said he handled 50 to 75 cases at a time and has no idea about those messages because that was the normal mode of communication at the time. He also says he never put anyone in an uncomfortable situation. Now, Nelson did agree to meet face-to-face, but on the day of our scheduled meeting, he said he had reviewed some guidelines for guardian ad litems and felt he could no longer discuss the allegations. Now, Nelson tells me via text message he hasn't been a guardian ad litem in almost 2 years, but is still currently working as a magistrate judge in Columbia County.
Judge Roper let the slack out on his leash so he could just do and have whatever he wanted.
He doesn't want to show his face or share his name, but this young father says Doug Nelson was the guardian ad litem assigned to his case, one that didn't get a ruling in his favor.
He pretty much did whatever he wanted to do with no regard for me and my family.
Father says the ruling is surprising because of his ex-wife's trouble with the law. Nelson's August 12, 2013 Guardian ad litem report notes the wife's 2012 arrest for manufacturing marijuana and child neglect, charges backed up by past court records. Nelson also noted the mother's charges were dismissed and she was working to get them expunged. And according to court officials, the charges can no longer be found on the books. Nelson recommended the mom get visitation rights, but Superior Court Judge David Roper took it one step further. He said after considering several factors, he said the child had a better bond with the mom, and in a final ruling on August 12, 2013, gave her primary physical custody. We did call and text listed phone numbers for the mother, but have yet to hear back. The father says he decided to step forward after seeing our original story where women accused Nelson of being inappropriate with them. He says he saw some similarities in his own case because of what he says one witness was sent.
Similar text messages that were as inappropriate or even more inappropriate in some cases.
In documents the father gave us, local attorney Andy Tisdale emailed screenshots of text messages to Judge Roper on August 22, 2013. Nelson allegedly sent the messages to the child's teacher, who was a witness on the case. We reached out to Tisdale, who did not represent the litigants or witnesses in this case, and he confirmed the authenticity of the email but denies releasing it to other parties. In the messages, Nelson tells the teacher she's the most beautiful he's ever met and that he came to the school to see her, waiting for an hour in the office after music class. She thanks him for the compliments and for being honest, but then tells him they must keep their communication professional. Multiple attempts to contact the teacher were unanswered, but in a sworn statement on August 12, 2013, the teacher confirmed she did receive what she called inappropriate remarks to her cell phone, and they were reported to the school principal. However, Judge Roper says he did not allow the statement to be admitted as evidence in the case, and he says it is his policy not to discuss the specifics beyond actions in active, past, or upcoming cases. Multiple calls, emails, and messages for the school principal were also unanswered. We asked Judge Roper about the email. He confirmed he did receive it, but says since he had already ruled on the case and since Nelson had resigned as a guardian altogether on August 13th, the point was moot. When we pressed him about not reporting the text messages to another agency like the police, he said while the messages were inappropriate, he didn't feel the crime had been committed and that sexual harassment is not a crime in Georgia. Father in this case says he felt hopeless about the situation.
I tried every legal route I could think of to get help, and no doors opened up for me. No one was willing to help.
And now, of course, we reached back out to Doug Nelson for comment on these new allegations, but since our original story has aired, he has not returned repeated calls and text messages. They actually reversed and remanded Craig's judgment because they say it was based upon erroneous views of the law and its improper consideration of matters outside the record. Now, the mother has agreed to talk to us about her case on the condition we hide her identity.
And the findings at the end, they really didn't have anything to do with what actually took place in the courtroom.
This mom is talking about the way she says Judge Daniel Craig ruled during one of her custody hearings after her divorce. She says he gave her ex-husband primary physical custody initially, even though her role had always been as a stay-at-home mom.
Honestly, it was and still is my life passion. It really is.
In his judgment, Craig cited several factors, which he said weighed in the father's favor, including the stability of the parent's support system, health of each parent, employment schedule flexibility, and the willingness of the parent to work with the other. But the court battles weren't over yet. In 2010, court records show her ex-husband petitioned for sole custody and restriction of her visitation rights, and Craig granted that based on precedent set in a past court case and a Division of Family and Children's Services report.
I don't know the contents of the defects report,
but someone else apparently did. The Court of Appeals says Craig noted he had reviewed the defects records and had used information gleaned from that in reaching his verdict, but it was never entered into evidence, nor did anyone from the agency testify, according to the Court of Appeals ruling. They say Craig erred in considering matters outside the record. The Court of Appeals also took issue with Craig denying the mother's request for access to that report, saying Georgia statute requires she be provided with it when being used in determining the issues before the court.
Judge Danny Craig misapplied laws, misinterpreted them, used them against me.
The DFACS report is not the only thing the Court of Appeals took issue with. Their ruling says Craig relied on an outdated case when making his decision, but the rule set in that case was abolished by the Georgia Supreme Court in 2003. While the 1955 case gave a prima facie right to the custodial parent, the 2003 case threw out that rule and eliminated a requirement of showing change for the worse when deciding custody. After all she says she's been through, the mom has this final message for Judge Craig.
Please step down. Step down. Haven't you done enough?
Now, we did reach out to Judge Craig for comment on this, but he says he doesn't comment on past, present, or future cases he may preside over.